one.
This Honorable Court of Appeals of Tennessee is in session.
Thank you, Ms. Dempsey. And on behalf of Judges McBrayer and McGee, we welcome counsel to this oral argument, which we are live streaming to fulfill our obligation to keep our courts open to the public. We will conduct the hearing in the same manner as if we were in the courtroom together. Each side has 15 minutes, and the appellant has the right to reserve some time for rebuttal, and I understand that has already been programmed. Thus, unless there are any announcements, I'll ask Ms. Dempsey to call the case.
Donny and Parsley versus City of Manchester, Tennessee.
Very well, the appellant has the floor.
Thank you, Judge. May it please the court, Jeremy Parham here on behalf of the appellant, Donny Parsley. And Your Honor, I will apologize to the court. I picked up a head cold sometime in the last 24 hours, so if there's any trouble understanding me, let me know, and I'll try to do my best. But
I'm sure Mr. Yule had something to do with you getting that cold.
I suspected the same thing, Judge. But Your Honor, we're here today on the appeal brought by Mr. Parsley. This stems from a declaratory judgment action that was filed in Coffee County in October of last year, almost exactly a year prior to where we are here today. And the basis of the declaratory judgment action was Mr. Parsley's position that under certain provisions of the City of Manchester Charter, he would have been the rightful individual to fill a vacant position on the Board of Aldermen. At that point in time, on October 12th of last year, then Mayor Lonnie Norman passed away due to complications, I believe, arising from COVID-19. It was then Vice Mayor Marilyn Howard who subsequently assumed that role after being appointed by the remaining members of the board, leaving a vacant position on the Board of Aldermen. It was Mr. Parsley's position at that point in time, and remains his position at present, that under the provisions of the charter, there are a number of different mechanisms by which that a vacant position on the board can be filled. Some of those require action by either the board or the mayor within 60 days. But if you follow along towards the end of that provision of the charter, which is subsection C, and it's part of the record in this case, that portion provides that aldermanic positions being filled for the balance of the term shall go to the next highest vote getter, with the top highest vote getters being elected to the regularly rotating aldermanic seats. It's undisputed in these proceedings that Mr. Parsley in the last election cycle would have been the number 4 vote getter. The way that election works in Manchester is that you have 6 alderman positions. They are staggered 4-year terms, and 1/2 of the entire board is up every 2 years. So that would mean you have 3 positions coming open with every election cycle for the board. And as the number 4 vote getter for the last election cycle, Mr. Parsley would have been the, quote, next highest vote getter in the election most recent to the passing of Mayor Norman and the vacancy which opened up within the board. So essentially there is a dispute between the parties, between Mr. Parsley and the City of Manchester, as to the interpretation of language within subsection C of the city charter, dictating how that position should be filled. It is, I understand, the city's position that that last sentence in that subsection applies only to filling the position after the next special or regular election, and then the number 4 vote getter at that point in time fills out as is appointed to the balance of the term. It remains Mr. Parsley's position this is incorrect, or at least that it's inconclusive in the way that statute or provision is drafted, and that last provision is not a modifier for a special or regular election, but is instead a 4th means by which that position may be filled if the other provisions are not activated within the 60-day period of time that's prescribed within the statute or ordinance itself. So that's the basis for the appeal. The complaint was filed in Coffee County. Shortly after it was filed, both of the local judges recused themselves due to the fact they had personal relationships or knowledge of the parties involved. Judge Stanley over in Warren County was appointed to hear the case. After the complaint was filed, Mr. Ewell on behalf of the city filed a motion to dismiss, which in the court, if you want some further explanation, I can go into it. But shortly after it was filed, the motion to dismiss was granted almost contemporaneously to our filing of a response. So there was no evidentiary hearing on that. It was decided purely on the motion. After that motion dismiss was granted, we filed a motion to set that aside. which was heard by oral argument of counsel over in front of Judge Stanley over in Warren County. But again, it was purely legal argument at that point in time. And Judge Stanley then dismissed the action, finding that Mr. Parsley lacked standing to bring this declaratory judgment action, he not having any kind of unique injury, as would be required typically in a standing consideration. It's our position that is the only next highest vote getter. He is uniquely positioned and has injury subject to redress by this honorable court, which is wholly different and separate from that of the general citizenry within Manchester and Coffee County. And as such, he has standing to bring this action. I understand in the city's responsive brief, they've taken the position that, well, it's of no consequence because within the body of that opinion, judge addressed a portion of the complaint or portion of the claim, stating that he would not be entitled to judgment based upon the court declined to agree with Mr. Parsley's interpretation and dismissed upon that basis. And then Judge Stanley went on to hold that as it pertains to an overall interpretation or declaratory judgment as to how that provision should be interpreted, that Mr. Parsley lacked standing in that regard, because if you kicked out the language or if you sided with Judge Stanley's interpretation as to when the next highest vote getter language kicked in, and that was no longer applicable, then Mr. Parsley's standing was no different from that of the general citizenry there in Manchester. I would submit to the court it's inappropriate to parcel out the individual portions of the provision here of the ordinance from the charter, and that if Mr. Parsley has standing under the provisions as the next highest vote getter, that's sufficient standing under relevant case law in order to bring this action, and under the statutes in question. So that the other portion of that is that, as I'm sure the court's aware, this is a declaratory judgment action. Motions to dismiss are typically not favored under those types of actions. And it's not up to the plaintiff or the petitioner in a motion to dismiss a declaratory judgment action to show that they're going to ultimately win on their argument, simply that they're entitled to have the relief or entitled to have the action heard by the court, and a declaration as to the parties' respective rights and obligations. Based upon the fact that the court went ahead and heard this matter on a motion to dismiss, the appellant was deprived of any opportunity to present in a proper hearing his testimony, records or minutes from the board when this ordinance was enacted, or any further proof which may have clarified the proper interpretation of these apparently conflicting provisions of the local charter. And it's for those reasons that the trial court erred in granting the motion to dismiss, and we respectfully ask this court to overturn that opinion, submit this case back to Judge Stanley for a full evidentiary hearing as to the declaratory judgment action.
All right. Anything further, Mr. Parham?
No, Your Honor, unless there are questions from the court.
Very good. Hearing no questions at this time, we'll hear from Mr. Ewell.
Please, the court. I'm Gerald Ewell Jr., and I represent the city of Manchester, Tennessee in this. I think the real issue boils down to just looking at the complaint in and of itself, as the rule requires under a motion to dismiss. And Mr. Parsley's position is just simply not tenable under the language of the charter, which is part of the complaint. You can take it for granted that he was the fourth highest vote getter in the election prior to the vacancy, and then you can just simply read section 6 of the charter, and it purely deals with the next highest vote getter in prospective terms. It says that the vacancy being filled prospectively shall be filled by the next highest vote getter at the next regular election. It's not the previous one. In order for Mr. Parsley to prevail, he has to convince the court that next means previous, and it just doesn't. And back to the procedural aspects of a declaratory judgment, motion to dismiss, etc., you do have to show some sort of colorable claim to it. And I've cited a lot of extensive case law in my brief about the standing issue, that in order for you to, that it's not just claiming a controversy exists. You've got to allege facts that shows that there's upon a careful examination of complainant's allegations to determine whether he's entitled to an adjudication. And the city would simply assert he's not entitled to that because he doesn't make a colorable claim. He just says previous means next, and there's just no other way to interpret it. And again, I cite the Metropolitan Air Research Testing Authority case as where the claimed injury involves, in that case, a violation of a statute, but in this case, it's the charter provisions. The court must determine whether the statutory provision on which the claim rests properly can be understood as granting persons in plaintiff's position a right to judicial relief. Just by pure reading that, the whole paragraph, section 6 in context, see, it talks about filling the vacancies, and then it talks about all appointments until the next regular election shall, at the time of the next regular election, be filled by election. That's when the language about the highest vote getter appears there. It doesn't appear in the board picking it. It's just something that Mr. Parsley, taking his complaint and just looking at it, reading what he says, reading the charter that's appended to the complaint and becomes part of it. It's just not him, and it's obviously not him, and it was appropriate for the court to dismiss it.
Well, I mean, the claim here, I mean, I don't think the statutory right of action case law is very helpful for us here, because the assertion obviously is under the DEC Act, and that's, they're asking to interpret the charter there. I mean, it seems like to me this sounds more like failure to state a claim and not lack of standing, because that you can't get a reading that gets, I mean, under your position, if we accept that, you can't get a reading of the charter position that anyway gets to Mr. Parham's client.
I would agree with that. I do think it fails to state a claim. And also, if it doesn't state a claim, dismissal is proper. Also, the case law is clear that if you don't have standing, you don't state a claim. It gets over into things with the court has dealt with on jurisdictional standing, constitutional standing, and other standing. But I would agree with Your Honor that Mr. Parsley's complaint does not state a claim, and that's and was properly dismissed on that ground, even under the declaratory judgment action. Now,
Mr. Ewell, Mr. Parham raised a good point, and I'm not sure how to handle it. I've thought about it before this argument, but there are cases that say declaratory judgment actions should be decided, and they shouldn't be dismissed for failure to state a claim or some other grounds. Because if it's a failure to state a claim, that in essence means that the court has determined that the defendant should prevail on the merits of the case. So you leave the parties without a resolution of who has what rights in this action. And then that brings me to what I find to be the confusion in my mind is to decide whether this case should be dismissed. The court almost has to decide whether next does or does not mean previous, which gets to the merits. So instead of dismissing the case for lack of standing, should not the trial judge have said next does not mean previous, and therefore the plaintiff is not entitled to relief because his claim is contrary to the meaning of the charter? I know that's a circuitous argument, but
No.
You might get to the same result and you might not. But there are authorities out there that say you shouldn't dismiss declaratory judgment actions like you would a suit for personal injuries.
That is absolutely correct. And I've attempted to address that by citing that you're correct that to decide that no claim is stated is to decide the issue in this case. I frankly,
Yeah.
that does it. And but there's also some cases that that's okay because the declaratory judgment, I think it uses the term, is not a ticket to avoid standing or to avoid these things, and that and I did also cite Rule of Appellate Procedure 36 too, which is somewhat the harmless error part, that by finding that there's no claim stated, the issue is decided and he got what he wanted. In fact, there's actually some language in the order doing the final part, or doing the motion to alter or amend, that says the court concluded that he did not fall within the parameters of being entitled to that, and in essence declares it. So we are getting to, yes, it's, some people would say tautological or circuitous, or by stating the resolution, it resolves the court. By dismissing it, it resolves the question. That's true, and some questions are just like this. But there, and as Your Honor observed, there are some cases that say generally you don't dismiss a declaratory, but there are others that say, just because somebody claims there's a controversy or whatever, they doesn't mean they're entitled to a declaratory judgment. That that you have to look into these things, that you have to look into the statute under which they're claiming, metropolitan area research thing, and then the other one that says that it's not a ticket to avoid the standing inquiry. That merely claiming that there's a dispute does not necessarily make there one, and you could not state one, and the issue ultimately be determined, as Your Honor said, by finding that it doesn't state a claim determines the issue. And they're just
perhaps. Yeah.
And if I think as my brief somewhat addresses that argument, what he's really complaining about is that Judge Stanley's order didn't say, I declare that Mr. Parsley's not entitled to this seat, in those words, but he does it in other words. So whether it's
I wonder if the filing here had been a judgment on the pleadings, would the analysis and outcome have been any different rather than a motion to dismiss?
Well, when I was writing my brief, I thought about that, but I didn't investigate it, as I had not filed a motion for judgment on the pleadings. But even if the result was the same, under Rule 36, you can, and under the court's case law, if it's decided for the wrong reason or whatever, but decided correctly, you can affirm it. So it's one of these things that we're somewhat in an esoteric form over substance here, because Mr. Parsley got a declaration. It might even be considered explicit at some point, even though it doesn't say I'm declaring this, and it's followed by, a dismissal of his lawsuit. Probably adding to that is, by dismissing, unlike a lot of the other ones, the Declaration of Rights would have affected people's conduct in the future and how they would have structured things. That's more of a concept under the standing, about you don't have standing if it doesn't affect your future activity. In this case, it didn't affect Mr. Parsley because he wasn't entitled to it. Now, some of the other cases that say it's, error to dismiss out of hand a declaratory judgment action, have to do with what people, I know there was one cited by Mr. Perrin Karsinovich. Mr. Karsinovich, if he didn't get a declaration, was going to have to pay some alimony. So it affected what he did. In this case, it doesn't affect Mr. Parsley because it doesn't make him do anything. It just says you're not entitled to this. So it doesn't really affect anything Mr. Parsley can do for himself in the future. Unlike some of the other cases, as Judge Clement observed, there's a big body of case law that says, generally, you shouldn't dismiss a declaratory judgment. I can't pretend that isn't out there, but there's also, what's generally true is not true in this, because, it's implicit in the dismissal that he gets a declaration. So it's really form over substance.
All right, anything further, Mr. Ewell?
Not this time, Your Honor.
All right, thank you. Mr. Parham, you have time for rebuttal.
Thank you, Your Honor. To the court, in brief rebuttal, I mean, we would freely submit to the panel that if this matter is heard to its conclusion by Judge Stanley, that Mr. Parsley may be wind up on the losing side of this argument. That's part of when you bring a declaratory judgment action. You know when you bring it, you've got a question. You may be right, you may be wrong. You just want the question answered. That's the whole purpose of a declaratory judgment action. The issue that we have is that procedurally, the manner in which this case proceeded, and it was a motion to dismiss, it wasn't a motion for judgment on the pleadings, is that within a matter of hours of the motion to dismiss being filed, or the response to the motion to dismiss being filed, it was granted without affording the parties any opportunity for further hearing in that, which essentially cut Mr. Parsley's litigation off before it even began, that there would have been discovery to be conducted and other things that would have turned.
Oh, but I mean, I wonder what discovery would, I mean, if a trial judge looks at this language and says, this is clear to me, I mean, what more would there have been to do? I mean, I know you say you would like discovery, but I'm not sure if the language is clear and unambiguous, there needs to be any discovery.
Well, it would have been our position, Your Honor, that if discovery had been permitted, or at least some time for it in this case, that we would have the opportunity to at least look into the records and minutes maintained when these provisions were passed to get some insight into the intent. And the whole question comes down to what is the last sentence in that provision? Does it stand alone in a fourth means by which the alderman position can be filled when vacated unexpectedly, or does it modify what happens after the next regular special election? That's the question. And we would concede to the court that ultimately, if that question's answered, if Mr. Parsley doesn't like the answer to it, he suggests to live with that. And the only recourse at that point in time would be, if he wanted to change that, to get either run again or get people elected who would change that provision. But he never got the opportunity from the trial court, because I would submit that language contained within an order that essentially says, well, if we've gone forward, this is what I might have found, is not the same as an affirmative declaratory judgment order stating this is how I find this statute or ordinance to be properly interpreted.
Anything further, Mr. Parham?
No, Your Honor. Thank you.
All right. Thanks to both of you for your briefs and your argument, and we will take this matter under advisement. Ms. Dempsey? You're muted. I can tell you, Ms. Dempsey, you're muted.
This honorable court is in recess until 3 p.m.
Thank you, Ms. Dempsey. And counsel, you are free to exit the Zoom meeting.
Thank you. Appreciate the panel's time today.